I just want to first open up by saying that it's very important to realize that what we're dealing with here, ladies and gentlemen, is brand new legislation. We're dealing with legislation that is ideally consumer-centric, which we will see from this webinar. And I must point out that the Act in itself is voluminous, it is challengeable, it's a litigator's dream. And of course, being a litigating attorney, it's the kind of thing that we're going to see being dealt with either by our courts and the highest courts in the land, or alternatively by legislative change. And what I want to preface this webinar today, which isn't a very long one, is that I'm only dealing with a few of the issues that have manifested itself in the rental property arena, what you need to be mindful of when you are running your rental business. And of course, what you can, I suppose, anticipate is going to happen as we move more and more into the birthing process of this act. Just by way of example, the Consumer Protection Act is still being debated and we are years down the line. The National Credit Act is still being debated and we're years down the line. The Rental Housing Act, which has been around for decades and which is subject to change in terms of the Rental Housing Amendment Act, number 35 of 2014, that in itself is also going to be up for change and challenge. So please bear in mind when we do deal with the Q&A, if I'm not profoundly aware of the answers to the question, it's because no attorneys will be, because this kind of act can easily be dealt with in a full 10-hour-day webinar. And even then, you won't scratch the surface of what needs to be done. So without further ado, just a bit more about us. We are a rental property law firm, commercial, contractual, and compliance. And as you would see from the banner on the right-hand side, we also have a club called the Rental Retainer Club, of which I'm proud to have over 500 agencies and landlords and agents who belong and pay us a nominal amount every month to have me on call 24/7, 365 to give them rental property advice. I'm proud to say that We Connect You is also a club member, and I really thank you for being as amazing as you are. So let's move on to the content of today's webinar. Firstly, I'm just going to have a glass of water because we're going to be talking a lot. In essence, the Property Practitioners Act has now come into play. And of course, the Estate Agency Affairs Act has been repealed, even though we are still seeing letters coming out on the Property Practitioners Regulatory Authority letterhead, but still referring to a repealed act. So they're still finding their feet. But I think what is absolutely vital is that if we are going to be looking at the impact of the Property Practitioners Act on the rental business, you need to understand as far as possible what exactly its impact is vis-a-vis lease agreements, mandates, your consumers, because inevitably the theme of the Consumer Protection Act has actually been dragged into the Property Practitioners Act. It's very much consumer-based. In fact, if you look at the Act and you have a time and a strong drink to do that, in essence, you will find that there is a section called consumer protection. So it's the same kind of logic to protect consumers, and that's where it goes much further than the Estate Agency Affairs Act. So there are many challenges coming, there are many idiosyncrasies in the Act, there are certain ways of interpreting it, and there are a number of excellent articles on the internet which you can read, which of course will enlighten you as to what the Act is all about in terms of generically. What you will not find, if I must say so myself, are the three aspects I'm going to be dealing with today, because essentially those are geared towards the rental business. And we will end up on the one topic that I believe is going to be the most prolific aspect of the rental, at least the rental agents throughout our country. And on that note, our focus will be on these particular topics: the mandatory disclosure forms, the incoming and the outgoing inspections, and of course, trust account exemptions. And we're going to shoot through it quite quickly because it is quite detailed. And hopefully at the end of this, you at least will have the ability not only to make an informed decision, but know what to ask your attorneys, know what to ask your accountants, know what best practice to bring in. Fortunately, as the author of the We Connect You lease, which of course is available by We Connect You, I'll be updating the We Connect You lease with the appropriate property practitioner clauses, and of course the mandatory disclosure, which I will mention just now. So let's focus on the mandatory disclosure forms. In terms of section 67 of the Property Practitioners Act, a property practitioner, and for our purposes, a property practitioner obviously includes a rental agent. You may no longer accept a mandate to manage a rental property, to procure a tenant to earn commission if your client, your landlord, has not completed the mandatory disclosure form. This mandatory disclosure form is clearly shown in the regulations to the Property Practitioners Act, and it's got to be attached to your agreement of lease. So, inspection list attached to the lease. At the end of the lease, there's going to be an outgoing inspection to be married up with the incoming inspection. House rules, if any, attached to the lease. So beyond that, you now have a duty to attach a mandatory disclosure form duly completed by the landlord, by the agency, and of course by the tenant. It's debatable whether the agency needs to sign that, because as I mentioned just now, our act in its absolute wisdom is a bit idiosyncratic over when or who or how it applies. For example, Section 67 of the Property Practitioners Act clearly says it applies to rentals and to sales. But ironically, when you look at the actual form, the actual document in the regulations that has to be completed, it only refers to sales, it only refers to sellers and purchasers. So what we have done is we have created a template document for rental agents, and it is freely available to all those delegates who are taking the time and giving us the privilege of their attendance today at this webinar. Moving on. The problem with this mandatory disclosure form is that it's very much open in the air. And the problem is, though, is that oftentimes you will find that as a rental agent in particular, not a sales agent per se, because sales agents are very document centric, but we have a number of rental agents, and being on retainer with over 500 agencies, we oftentimes see rental agents saying, Marlon, I don't have a written mandate per se, I just have a lease agreement and I'm not really a party to that lease agreement, but I found the tenant and I'm entitled to my commission. What the Property Practitioners Act is going to do is going to make it far more difficult, if not impossible, to actually earn commission on the basis of an oral or tacit mandate. So when you are faced with a scenario that a tenant says, or I've been procured, or the landlord says, hi Marlon, please just find me a tenant, that no longer will suffice for you to earn your procurement commission, unless you can show that prior to procuring that tenant, prior to taking over the right to manage a property, there is a mandate and it is accompanied by a completed mandatory disclosure form. The problem is, and this is where the rental business exposure comes about, is that if a disclosure is not completed, signed, and attached to the lease, then the lease agreement will be interpreted as if there are no defects or deficiencies with regard to the property. So just take a step back and realize that. If a tenant moves into a property, if there is no mandatory disclosure form which clearly indicates what defects and deficiencies there are, and it's not signed and not attached to the lease agreement, effectively the tenant is moving into a property that is free of defects and free of deficiencies. Now, if you think of that even further, what does that mean come the end of the lease agreement? What does that mean with regard to commission being earned? The actual exposure is huge. And let me carry on what I mean when I say that. If a tenant moves into a property and there is no signed mandatory disclosure, which points out the defects and the deficiencies in the lease agreement, and even though we know theoretically this is more applicable to a sales transaction, because sales transactions include purchasers who are left in the dark without knowledge of the defects, and in order to prove that the seller had knowledge, they would have to prove fraudulent misrepresentation and get locked into litigation. So the fact of the matter is that when a tenant moves into a property and there are no defects and no deficiencies, but the tenant discovers these and there was no mandatory disclosure, that could potentially serve as a basis for a tenant to say, you know what, I'm cancelling this lease. It's impacting my ability to enjoy the property. I don't want to be here anymore because had I known about those defects and those deficiencies, I would not have moved in, or alternatively, I would have paid less. So that is the first real problem that will manifest itself if there is no mandatory disclosure. And of course, you're then looking at a situation where a landlord suffers potentially irreparable harm when a tenant moves out without having to pay any penalties. If you go further, in section 67.3, a property practitioner, based on what the Act says, may actually be held liable by an affected consumer. The word effective consumer is the actual terminology used in the Property Practitioners Act. And what it says is, if a mandate was accepted by a rental agent, by a property practitioner, and there was no mandatory disclosure that was completed, that property practitioner may actually be held liable by an affected consumer. Now, if you think of that logically, a property practitioner could potentially be held liable by a tenant, even though there's no legal connection between a rental agent and a tenant. A tenant could turn around and say, well, I'm holding you liable because I am an affected consumer. Of course, an affected consumer could also be a landlord, because don't forget, an agent is a supplier, a landlord is his consumer, a landlord can be a supplier, and a tenant can be a consumer. The Consumer Protection Act has totally muddied the waters as to suppliers and consumers. In fact, if you look at the definition of a user in terms of the Consumer Protection Act, it includes anyone who signs a lease agreement, or anyone who is a party to that agreement, or is a recipient of services of that agreement, even if they didn't sign that agreement. So it is therefore possible that if a tenant suffers a loss as a result of defects in the property where there was no mandatory disclosure, the agency may notionally be held liable for those damages. What those damages are, we don't know, but they could be reported to the PPRA, which is the Property Practitioners Regulatory Authority. They could be fined. But the bottom line I want you to take from this is that there is now a new form that has to be completed before a rental agent can market the property to tenants, procure a tenant, and earn commission. And the bottom line on that is that we now have a new onus on a rental agent to make sure the mandatory disclosure form is completed. So the practice that I see developing is that there will no longer be possible oral mandates or tacit mandates. Signed mandates between landlord and rental agent is going to be the aim of this act, because ultimately it's to protect the underlying consumer, which is the tenant. So moving on to the second of our three aspects today is the incoming and outgoing inspection. And we must question, why does the Property Practitioners Act even involve the incoming and outgoing inspection? Well, the truth is, it doesn't per se. The Rental Housing Act, as you would well know, is clear and unchangeable in terms of the fact that it requires an incoming and an outgoing inspection. That hasn't changed in terms of the Property Practitioners Act. It will not change when the Rental Housing Amendment Act comes in. For those of you who saw me in the last masterclass, that webinar was on the Rental Housing Amendment Act and the changes that's going to bring to the rental industry. So why exactly are we talking about incoming and outgoing inspections? And I think it's very simple. If there is now the duty to have a mandatory disclosure form attached to the lease agreement, is this mandatory disclosure going to replace a potential incoming and outgoing inspection? Well, the cold answer is no. Section 67 says there may be a need for inspections to be held, and nothing precludes the tenant from having his or her own inspection. The bottom line, however, is incoming inspections and outgoing inspections must still take place. But what is totally unchallengeable is that there must also be a mandatory disclosure. So the question is, why would we have a mandatory disclosure form plus an incoming inspection? And the short answer is the following. There is a clear distinction between a mandatory disclosure form and, of course, the incoming inspection form, and that is as follows. The mandatory disclosure form appears to be focused on permanent defects, boundary disputes, and structural issues. Obviously, when it comes to incoming and outgoing inspections, we are dealing with the deposit issue, we're dealing with fair wear and tear, damages, fixtures, fittings, paint, etc. Incoming inspection records the status of the property. At the end of the lease, there is an outgoing inspection whereby the deposit plus interest is refunded, except for any damages that are not fair wear and tear. But that mandatory disclosure is the most important document, because if that is not signed and attached, the agency is exposed by virtue of the fact that they won't be able to earn commission and potentially face some challenge from the tenant by way of negligence. Of course, that is not defined, but again, we are trying to mitigate against our exposure. And that's why the topic is how to mitigate against potential exposure to your rental business. So in short terms, you need both a mandatory disclosure, you need the incoming inspection. Both are complementary and mandatory, and both need to be performed in order to protect the rental business. I think it's important to note as well is that there can no longer be a reliance on the fact that you didn't have the form in front of you, or it wasn't signed or wasn't completed. The word mandatory is compulsory. And until we find legislation or case law which says it's not necessary, or case law which demonstrates that this was ideally meant for the sales industry, we must continue as if it is law. And as I mentioned, it's going to be challenged in court. It will be challenged in the legislature at some stage, just like recent legislation or previous legislation is continually redefined by virtue of clever advocates and attorneys arguing in courts of law. And finally, trust account exemptions. The reason why I've made this a focus is purely to show that many rental agents are of the belief, whether correctly or incorrectly, that being exempted from holding a trust account is like the mecca of being a rental agent. Why have all the necessity of trust accounts, audits? Are we now allowed to give up our trust accounts? What is our turnover required? I can tell you right now that it is a very intricate and technical section. This part of the webinar is purely to focus on a couple of aspects which I think need to be dealt with. And I do encourage you once again to please read through the articles on the internet dealing vis-a-vis with exemptions, speak to your accountants, speak to your attorneys. It's very detailed. That's much I can tell you. And what I can tell you more is that Regulation 2 and Section 23 of the Property Practitioners Act are the sections and regulations of the Property Practitioners Act, in which it details the circumstances where you may, as a rental agency, apply to be exempted from holding a trust account. And I know acting for rental agents every single day, issuing summonses, doing evictions every single day, and protecting landlords to the club and protecting rental agents to the club, they keep saying, Marlon, why must we have a trust account? It's an expense. Why do we need to have a trust account if you're not holding deposits? Well, ladies and gentlemen, here is the answer, and hopefully some guidance on what you can do about that. Firstly, where your turnover is below 2.5 million Rand, your accounting records do not need to be audited. They can simply be subject to an independent review by a registered accountant. That is a huge cost saving, potentially. The regulations also provide, secondly, that you can apply for an exemption from having a trust account if, for example, you've never held trust monies or you no longer intend to hold trust monies, and you must be able to prove that, of course. And in such a case, what you need to do is to notify the Property Practitioners Regulatory Authority, the PPRA, provide an affidavit where you set out that you've complied with Regulation 2, as previously mentioned, where you undertake not to hold any trust funds, and where you provide clear, unequivocal evidence that you will not be getting trust money in the future. For that purpose, you will then be able to obtain the right to be exempt from holding a trust account. There is a separate train of thought, which I won't go into, which actually says you don't need to be under 2.5 million Rand. Because if you look at Section 23(1) of the Act and Regulation 2 of the Act, you can potentially read it that you effectively can apply to be exempt even if you're over 2.5 million Rand. My best advice to you is, if you want to be exempt from holding a trust account, write to the PPRA, enclose an affidavit, telling them you don't handle trust funds, telling them you don't intend to hold trust funds going forward, and see what they say. To bring the webinar to a close, and the reason I keep drinking water is because I'm talking a lot and I'm thinking through what I'm saying, because I'm trying to make this as simple as possible. So please bear in mind that what I'm going to tell you now is my own viewpoint. It is a perception of what I see with those payment processes who are jumping on the bandwagon, trying to convince rental agents that they need to withdraw from holding a trust account. They need to apply for an exemption because these payment processes are doing it for them. And I want to leave you with the idea that the essence behind We Connect You, the essence behind dealing with your own trust account, besides the control aspect of it, is that it's best practice. It's important to be aware of the purpose of your trust account, why you would use it, why you need it, and why it's of value to consider not applying for an exemption. And the fact of the matter is that you can be exempted from operating a trust account if you have mandated another property practitioner that specializes in collecting and distributing trust payments. And if you have a payment processor, whomever that is, to process your trust amounts, you are exempt from holding a trust account and, of course, exempt from having a trust audit. But once you are exempted, besides the fact you will not have to have your annual financial statements audited, and it only needs to be reviewed by an independent accountant, a chartered accountant. It goes further when you look at what the implications of doing that are. Please bear in mind that this right to an exemption clearly applies without any problems whatsoever to individual practitioners. So as a point of departure, off the cuff, if you are a sole proprietor, so to speak, you're automatically exempt from holding a trust account, unless of course you receive trust monies, obviously. But if you are a business practitioner, that would be a partnership or a trust or a incorporated or a CC or a company, any type of juristic entity, of course, you would need to apply for that exemption if you are, of course, using a payment processor. So why am I focusing so much on this? Well, the fact of the matter is exemptions from holding a trust account is something that is a concerning element, because if you are assigning the control factor of your trust account, which is the very account where you hold deposits, which is the very account that is utilized for purposes of refunding deposits to landlords, to tenants, it is the holy grail. And the auditing of that establishes the best practice in how you are running your business, not dissimilar to a law firm. Our trust account is audited by the Legal Practice Council. They can see from the transactions what exactly we're doing, how we're handling the trust money, and for that we are granted, not dissimilar to the property industry, a fidelity fund certificate ourselves. So the point needs to be made that where payment processing agents are employed, they only take over the function of payment processing from the agency. The agency no longer needs to be audited, but the mere fact that you have an agency that is being managed in terms of their trust account from a third-party perspective does not absolve that agency from still handling trust monies in accordance with the law. In other words, you still remain liable in terms of what happens in your trust account, even though your trust account is being audited by a third party because it's managed by a third party. And I want to use my legal fraternity as a prime example. We are not allowed to outsource our trust account management. We use our trust account for collecting deposits from clients, just like a property practitioner would. We hold deposits in our trust account for a potential sale. We hold deposits in our trust account for potential work that we do. And if we had to hypothetically outsource it, we would still be accountable to the Legal Practice Council for what happens in that. And you can be rest assured that any payment processor that is managing your trust account is identifying themselves against any problems that manifest itself in your trust account. What if the payment processor pays the wrong agent, wrong party, or the wrong agent, or does something that is purportedly illegal? They won't get into trouble. And in any event, their audit is effectively checking the numbers. The audit of a payment processor, what we understand, and I stand to be corrected, is not the same as an auditor auditing your personal trust account. It goes much deeper than that, and there's a lot of value to knowing that if your trust account is healthy and managed well, then you are effectively doing best practice. So that's why I want to conclude this webinar by mentioning a few things that every property practitioner should keep in mind when applying for an exemption, especially when they use a payment processing agent. Firstly, 100% of the risk remains with the rental agent. And the bottom line is that the money that is in trust remains your liability. In other words, if you are outsourcing the management of your trust account to a third party, even though they are effectively managing your trust account and you're no longer the owner, your duty, your liability to your own landlords, to your own clients remains with you. So you are not exempt from the liability of the transactions that occur and are processed through your trust account, which is quite a scary thought. And of course, to have no independent third party actually audit your personal trust account, which means there is a potentially increased risk. As I mentioned, a payment processing agent's trust account that is audited is very different to an audit of your personal trust account. You have no control thereover, and you have to rely on a payment processor to do so. It is not to say that it is not of assistance to you. It's not to say that a payment processor might not give you good value. The point, though, is that by asking for that exemption, be mindful of what you are asking for and why you would want to have that exemption. You may well be over 2.5 million Rand. You may well be dealing with a lot of trust monies, but your seeking an exemption could potentially present a problem because you give up de facto control of your trust account. Another problem, and why I've made this so, I suppose, specific with regard to concerns that I have, is that in terms of the new Property Practitioners Act, we now have inspectors who have this incredible power to inspect your premises, your financial records at any given time without a search warrant. And I encourage you to read Section 25 of the PPA, and effectively allows those inspectors to determine what exactly is happening with regard to the financial aspects of your records. And I can tell you that if you are found to be in breach, there may be a fine of up to 200,000 Rand or a maximum prison sentence of up to 10 years. I'm not saying that this will happen, but what I'm saying is if you look at the sections, you don't want to be in a position where issues are raised with regard to your financial records, with regard to your trust accounts that you're not in control of just because it's been outsourced to a payment processor. With having an audit, it will consider whether you are compliant with all the laws in place and the regulations. It does not just focus on the numbers, which invariably is what a payment processor focuses on. I know this is all up in the air and it's technical and it's not as funny and commercially viable to talk about, because I usually try to bring humor into my talks. For those of you who know me and have been to a lot of my webinars, I'm trying to make this as not funny, but as logical to understand in a fair and efficient way. But the fact is that this new legislation is clearly draconian. It's basically saying you can outsource to a payment processor. You're allowed to do so, but we're not putting any protective measures in place for you. In fact, we are allowing inspectors to pop over anytime and effectively take cognizance of what you are or not doing. And you can't turn around and say, well, I've got no control of my trust account. It's with a payment processor. So therefore, we're going to try and put you in jail for 10 years. I'm not saying you will go to jail. I'm not saying you're going to get a fine of 200,000 Rand. But what I'm saying is there doesn't seem to be an effective balance between you having a right to exempt yourself from running a trust account and the consequences of what may happen if you don't. So with an audit, owning your own trust account, you are alive to being compliant, you're allowed to putting measures in place, and of course, you also potentially have the cost of an audit, but it comes down to opportunity cost, which is what we will end off with. Besides the fact that you don't have control of your account, you lose the potential of having value of having that trust account at the bank if you give up that right to a payment processing agent. And of course, a payment processing agent is not free. So if you consider what kind of book you have, the turnover you have, what is a payment processor going to charge you in terms of a monthly fee? Work that out over a year period, what it's going to cost you every month, and then say to yourself, well, what's it going to cost me to own my own trust account? To maybe use a different type of processing agent, so to speak, to assist you in your bank integration, in dealing with your property management company, in using other people to help you, I suppose, digitize your system, and what that cost is. And if you potentially weigh up that cost every month, plus potentially the cost of an audit, do those two accumulative costs equal the cost of the fee that you pay your own payment processing agent? I think it's something worth doing a cost analysis over. So consider the true cost and the true benefit rule for using a payment processing agent, for asking for exemption from your trust account, and for very much understanding what is the best practice for your business. Of course, when it comes to trust accounts, one of the things that rental agents do is they hold money on behalf of their landlords. They hold money on behalf of the sellers. They hold money when there are disputes between their landlords and their tenants because they don't know what to do. And it's one of the big things that we handle is that a landlord is holding a deposit and he says he wants to pay the tenant because there's no damages to the property. The landlord says, no, there are damages, please pay me. The rental agent can't pay the landlord because then they're breaching their mandate and they're breaching the Consumer Protection Act because they're not giving their consumer the best care. And then if they don't pay the tenant back, then they're breaching the Rental Housing Act because there's a limited time period within which a tenant is to be refunded his deposit. So what do? They retain the deposit in their trust account. If that is potentially handled by a payment processing agent, are you then shifting your duties to a third party? Maybe that's advantageous, but it means you effectively lose control. Then again, there are ups and downs to using these types of things. What I'm trying to say, and I want you to take away from this webinar, is that the exemption from holding a trust account now could potentially elicit the wrath of inspectors. It could be a cost factor. And we don't want rental agents to lose control unnecessarily unless they dutifully do not hold trust amounts or do not handle trust amounts or don't want to handle trust amounts again or are below a 2.5 million rand turnover. But if you are handling trust amounts and you are above 2.5 million rand turnover, weigh up the costs of exempting yourself and what impact that may have, not only on your company, but on the perception of your company. And on that note, we're going to bring this webinar to a close. I just want to put it out there once again that this is brand new legislation. The EAAB still has their own website up. There is no Property Practitioner Regulatory Authority website. We are still learning the Act as we go along. The mandatory disclosure, which is going to be freely available, is clearly done to protect rental agents and landlords. And all I want you to take away from today is that you can't be liable for not understanding the legislation. Attorneys don't understand the legislation. All this is meant to do is to give you food for thought. So going forward, you are mindful of what potentially is out there and what to look out for when it comes to empowering yourself and educating yourself with fellow agents in your agency.